Hello everyone, my name is Mark Veloso, a contributor with Litigation Help, and welcome to our video series entitled Case Law Minutes, where we will highlight the most frequently cited family law cases listed on the Ontario Superior Court website. Our video today is on Czieslik v. Ayuso, decided in 2007 by the Ontario Court of Appeal. This is a family law case that concerns unconscionable pre-separation misconduct by a spouse, and what the court considers the appropriate remedy for such conduct. In von Czieslik v. Ayuso, the parties married in 1989 and were together for 11 years prior to separating. This was the third marriage for the wife and the second for the husband. Both parties owned properties prior to the date of marriage. Both placed mortgages of different amounts on those properties to assist with the purchase of the matrimonial home. In the case at hand, when the marriage began to deteriorate, the husband secretly transferred property valued at nearly $190,000 to a third party. Since that asset had been gifted prior to the separation, it was originally not included as part of the net family property. At trial, the judge found that the husband had engaged in unconscionable pre-separation conduct by effectively gifting property to a third party so that the property would not be included in his net family property on the date of separation. Despite this finding, the judge believed that the court was restricted in the amount it could award the wife under Section 5(6) of the Family Law Act. That remedy was restricted to half the difference in percentage between the parties' net family property, which was only $10,466. Subsection 5(6) of the Family Law Act provides for an award where the court is of the opinion that equalizing the net family properties would be unconscionable, having regard to a number of factors. If equalization is found to be unconscionable, Section 5(6) permits a court to award the spouse an amount that is more or less than half the difference between the net family properties. The question before the Court of Appeal was whether Section 5(6) of the Family Law Act allowed the court to award one spouse more than half the difference in the net family property as a remedy for the other spouse's unconscionable conduct. The court's decision ultimately hinged on the interpretation of the phrase "more or less than the difference between the parties' net family properties." The quote I've chosen to highlight comes from paragraph 25 of the court's decision in this case, where it is stated that a court may award an amount of money that is more or less than the difference between the parties' net family properties, since there is no cap, restriction, or limitation on "more than" on its face. The legislation does not limit such an award to 100% of the difference. In awarding the wife more than 100% share of the difference in net family property, the court took a broad interpretation of Section 5(6) of the Family Law Act provision, arguing that the plain reading of Section 5(6) does not support the conclusion that it only allows for reapportionment of the difference between the parties' net family properties. That interpretation would not be sufficient in many cases to provide a meaningful remedy in cases of unconscionable pre-separation misconduct, where the difference in value of properties is minimal. The legal rules, or ratio decidendi, derived from the court's decision in Czieslik v. Ayuso is that Section 5(6) of the Family Law Act permits the court to remedy unconscionable conduct by awarding 100% of the value of the offending party's net family property to his or her spouse. To learn more about the court's reasoning in this decision, you may access the case on the Canley website link provided above.